Sorry about that. Yeah, can you turn your speaker off? Let's try that. That's much better. Good morning, everybody. Welcome to our public hearing on the proposed amended and restated San Juan County subdivision regulations. If you are out in the rest of the world and are listening, my name is Doug Eccles. I'm the county attorney. The county commission appointed me to conduct this hearing. In a moment, we're going to see who may be present participating online so that we can take a roll and put that in the minutes of our hearing. In addition, I would point out that Mike Stark, county manager, Jim Cox, deputy county manager, and Larry Hathaway, community development director, are present in the commission chambers. Most of the presentation will be done by David Barnett, and Danielle Douthit is here taking notes and keeping minutes. Once we get going, what I would ask is if you have a question from the internet world, if you could either put your hand up, there's a button to do that, or put a note in chat. Mr. Neely will let us know we have questions. It'll be a whole lot easier, given the length of this document, to deal with them as we go, rather than try to save them up to the end. Do we have folks online, Devin? Can you tell us who's there?
Washington, Providence, Sawyer, Parker, Lane, Helen, Rand.
Okay. That'd be great. And we may be joined by some folks later. We'll just have to see the wonderful new COVID world. So before we actually start hearing from Mr. Barnett, I want to acknowledge that I've received and marked as Exhibit 1 a copy of the subdivision regulations so that we'll have it in the hearing record. As Exhibit 2 is the original San Juan County Growth Management Plan, and Exhibit 3 is the update to the San Juan County Growth Management Plan, particularly noting that within that plan, there are specific recommendations to what the county ought to do with its subdivision plans, both the exemption and otherwise, and that by state law, the county may alter the terms of the exemptions, the requirements of exempt subdivisions, if those changes are made in accordance with the growth management plan and the 2000, in our case, the 2018 update. If anybody listening doesn't have a copy of that update, please let us know. We'll be happy to get you one after the hearing is over. So at this point, I'm going to turn it over to Mr. Barnett, and we can start with his presentation.
Okay, thank you, Mr. Eccles. I am David Barnett, Subdivision Review Officer for San Juan County. The subdivision regulations were last amended in 2006. In 2018, the San Juan County Growth Management Plan was updated. Some of the proposed changes to the subdivision regulations reflect recommendations from that Growth Management Plan update. Other proposed changes reflect changes to state statute and the New Mexico Subdivision Act. And now I'll read through the proposed changes and give an explanation. Here, this document, hopefully everybody can see it. Okay. And so the first substantial change here is going to be in the definitions. So we added a definition for a compliance plat because it's quite common for parcels to be non-compliant. Often these parcels were split by deed instead of split with county and or city approval. The definition reads compliance plat, a plat of one or more parcels that have not previously received approval by the county and or municipality. These parcels were established after these regulations were effective July 1st, 1997, and or after a municipality's regulations took effect. An approved compliance plat brings these parcels into compliance with these regulations and or a municipality's regulations. And then the next change is for the definition of net lot size. We changed this definition because the New Mexico Environment Department has changed their definition, no longer excluding access easements from the lot area. If NMED changes their definition again, this definition would still apply. So it reads a net lot size, the area of a lot as defined by the New Mexico Liquid Waste Disposal Regulations 20 NMEC 7.3, and then deleting, excluding any area dedicated by easement or used to provide vehicular access, vehicular passage to more than one lot or more than 5 residential or commercial units on a single lot.
So, as I understand, as of right now, as these regulations sit, the portions of easements on parcels has been excluded from the net area for compliance for homes, such as like a 3/4 acre lot can only have a 3-bedroom, 2-bathroom house on it. Is that correct?
My understanding, yes, and because of the Environment Department's updated definition, they're no longer excluding those access easements.
Okay.
So
Yeah, and so I was just curious because I know for a couple of years now, I remember when I first started working here at Basin that I knew that was part of it, where the easements were excluded. And I know in recent years we've actually had lots approved simply because of the way that New Mexico liquid waste disposal regulations read. So did those? I guess my question is, did those override the San Juan County subdivision regulations? And are we just making these regulations more compliant with the way the New Mexico liquid waste disposal regulations read?
The intent, I believe, Mr. Lane, is that this paragraph would mirror whatever the solid or the liquid waste disposal regulations were. We always had relied upon what they would authorize in approving subdivisions.
Okay, perfect. And that's great. I understand. Perfect.
Good, thank you.
all right. Moving on here. Next revision. Okay, so in the definitions for exemptions, the 7th exemption had a passage here about this is the boundary line adjustment exemption, the division of land resulting only in alteration of parcel boundaries, where parcels are altered for the purpose of increasing or reducing the size of contiguous parcels, and where the number of parcels is not increased. We deleted the part after that where it says, and a plat showing the alterations and are prepared by a licensed surveyor is recorded with the county clerk. And that's to align with the current Subdivision Act definitions.
So what is your reasoning for removing that end of that statement there.
Just to align with the Subdivision Act definition.
Okay, but that doesn't remove the necessity of a plat needing to be done, correct?
That is correct.
Okay, thank you.
And so the 9th exemption is for family members. We added a 5-year holding period for family exemptions. And that was included in our growth management plan. The reason is that there have been landowners who may have taken advantage of the family exemption and not constructed a subdivision with the required improvements. So we added the wording to the end of the family exemption definition here, provided that the immediate family member shall not further transfer ownership or divide the land within 5 years.
Okay. Now, I understand your reasoning for wanting to try and keep people from getting around subdivision regulations. However, in all my years of surveying, typically the reason why family exemptions are done is so that particular family members can be given a parcel of land to sell in the event that they need the money. And that has been a way that parents have been able to, basically give their kids land for them to sell. And so I don't necessarily agree with, I could understand the transfer, but the sale, I feel like there needs to be verbiage, because I feel that a legal sale of a family exemption lot should be allowed in the event that that is being done for the benefit of the child or relative. I feel like that's what family exemptions are specifically for.
So all we can do at this point, Mr. Lane, is to note your objection and put it in our report to the commission on this hearing.
Okay, no problem.
All right, moving on, the 12th exemption, the donation exemption, facility was deleted and faculty replaced there. That we corrected that to align with the Subdivision Act. The 13th exemption, which is the 5-year exemption, we changed this definition to align with the current New Mexico Subdivision Act and continue to exclude tracts within previously approved subdivisions as the old definition excluded. So that would read now, the division of a tract of land except a tract within a previously approved subdivision within any 5-year period into 2 parcels that conform with applicable zoning ordinances, provided that a second or subsequent division of either of the 2 parcels within 5 years of the date of the division of the original tract of land shall be subject to the provisions of the New Mexico Subdivision Act, provided further that a survey and a deed, if a parcel is subsequently conveyed, shall be filed with the county clerk indicating the 5-year holding period, and that the parcel shall be subject to the provisions of the New Mexico Subdivision Act if the parcel is further divided within 5 years of the date of the division of the original tract of land. And we added 14th exemption, basically other exemption type for plats that don't fall under the other definitions for exemptions. The definition, it reads 14. The division or platting of land not defined elsewhere in these regulations, such as compliance plat, easement survey, revised plat, correction plat, or any other type of plat. Or another type of plat. That's red here. Another definition for type 5 subdivision. corrected that to align with the current Subdivision Act. So now it would read, any subdivision containing not more than 24 parcels, each of which is 10 acres or more in size. Okay, so in Article 3, the pre-application process, the pre-application procedure is defined, and let's see, the pre-application conference is explained. We made these changes to require a pre-application conference for all plat types. These conferences are helpful for landowners and surveyors, and they often took place even though they were not required. So in the conference in general paragraph, we added the word shall and deleted may to require that an informal pre-application conference takes place for all plats. And then we made some changes to the next section. So now it would read, a pre-application conference is required for all plats submitted to the subdivision review officer. Before, it was only required for summary review subdivisions. And then in scheduling, we deleted the part that where it was or wasn't required, since it's required now for all plat types. Let's see. In Article 4, the preliminary plat review process, we added a pre-application conference is required before application for preliminary plat submittal. The pre-application process is described in Article 3 of these regulations. As previously stated, we wanted to require a pre-application conference for all plat types. And there are some review agencies that we added to match our review procedure, namely the floodplain manager and the assessor's office. And we added some passages that ensure adequate water supply to reflect changes to state statute. And they read, as per NMSA 1978, section 47-6-11.2, for a subdivision containing 10 or more parcels, any one of which is 2 acres or less in size, the subdivider shall provide proof of a service commitment from a water provider and an opinion from the state engineer of adequate water supply or an appropriate water permit before final plat approval. As per NMSA 1978, section 47-6-11.4, on land from which irrigation water rights have been severed after April 4th, 2013, the subdivider shall provide proof of a service commitment from a water provider and an opinion from the state engineer of adequate water supply or an appropriate water permit before final plat approval. The notification section, we added either an email address or a self-addressed envelope for notifying persons who previously requested a notice. And we added this to provide notice by email as an option. And in the section covering preliminary plat, required documentation, at the end of that list, required documents, we added any lien holder or title company in lieu of lien holder acknowledges plat. We added this to ensure that mortgage companies are aware of proposed plats that change the legal description they hold as collateral. This is usually a letter from the mortgage company, an email, or a letter from the title company in lieu of the lien holder. In the filing specifications, And we made changes to this section to ensure that there are enough paper copies for distribution and digital copies of the line work for review. So now it would read filing specifications. The subdivider shall submit copies of the preliminary plat and supporting documentation in such number sufficient for local review and distribution, public review agencies, deleting the 10 copies. And the survey line work and lot numbers shall be submitted in electronic format acceptable to the subdivision review officer. And then we had comment from R. Clayton Harrison of CHC Engineers. David, I will not be able to attend the meeting, so I'm sending you my comments. Section 4.5.2, please allow digital only submittals, especially of the disclosure statement and supporting documents. Federal government passed the Paperwork Reduction Act way back in 1980 with one explicit goal of minimizing the burden to the public when collecting information. I can understand the county needing to review full-size plans and plats on paper, but in today's world, letter-sized documents don't need to be printed to review. And our comment back to that would be that we wouldn't be opposed to digital only submittals, but we think that the statute would not allow for it. Looking at the Subdivision Act. And another, I'll get to that one later. Mr. Harrison also had another comment on section 6.2.9. We'll cover that later. And under the requirements, map specifications section, we added the required signatures. So for preliminary plat would be a signature block for the Board of County Commissioners, County Clerk, County Floodplain Manager, and County Treasurer for full review subdivision. So for final plat, data requirements, filing specifications, we made changes to this passage because blue line copies are no longer needed, and to ensure that a digital copy of the line work is submitted. So at the end of the passage, we deleted, in addition to the Mylar original, the subdivider shall submit 3 paper blue line copies of the final plat and accompanying information. If available, the subdivision line work and lot numbers should be submitted in electronic format such as AutoCAD or DXF. And we added the survey line work and lot numbers shall be submitted in electronic format acceptable to the subdivision review officer. The recording section, we added the subdivider shall provide the recording fees required by the county clerk. We added this to clarify that the subdivider will pay the recording fees.
So David, and I'm not sure, I haven't read through all the changes in this document yet. Have you put anywhere in here that the new deeds with updated legal descriptions are going to be required with these, with any of these types of subdivisions?
Yes, Mr. Lane. I believe it's been amended to be worded within 2 weeks of the plat being filed.
Okay, awesome. Thank you.
So under the final plat approval section, we added a part to reflect changes to state statute. So we added the approval of the county treasurer or designee is required to ensure that all taxes, penalties, interest, and fees through the current taxable year are paid prior to real property being divided or combined. For the water permit section, we changed this passage to ensure adequate water supply to reflect changes to state statute, deleting part where it reads, a water permit from the state engineer is not required to receive preliminary, and deleted, or final plat approval. So, and the same passages that I read earlier concerning the requirement for a water permit and opinion from the state engineer would apply to this section as well. And under summary review, we revised the section covering plats, application, and fee to clarify the review and approval process, require a lien holder acknowledgement, and to ensure that a digital copy of the line work is submitted. So now this section would read, a subdivider shall prepare copies of a summary review plat and supporting documentation in such numbers sufficient for review in accordance with the requirements provided in this section, or provided in this article. Supporting documentation shall include, but is not limited to, documentation that any lien holder or title company in lieu of lien holder acknowledges plat, and then deleting the summary review plat shall be considered as a final plat suitable for recording in the office of the county clerk. And then going on, summary review plat submittal is initiated by completing an application on a prescribed form obtainable from the subdivision review officer, and upon payment of the required administrative fee, survey line work and lot numbers shall be submitted in electronic format acceptable to the subdivision review officer.
Please. Hello? If you're on the phone, could you identify yourself, please? Well, we'll come back to him. I hear. Go ahead, David, if you'd like.
Okay, moving on. Under section 6.1.5, we added review and approval to this section. We revised this passage to clarify the review and approval process and to add an expiration for summary review plats. So now it reads, summary review plats submitted for review, deleting approval, shall be reviewed and given preliminary approval or disapproval by the subdivision review officer within 30 days of the date the summary review plat is deemed complete. Revised summary review plats must be submitted to the subdivision review officer for final approval if the summary review plat is not signed by the summary review officer within 12 months after receipt of all review materials. The application for summary review shall expire. An extension may be granted by the subdivision review officer. So, some main changes to section 6.2 to clarify the final approval requirements because blue line copies are no longer needed. So we changed original to final, so it reads, the final drawing of the summary review plat shall be submitted in waterproof ink on Mylar. And then at the end, we deleted the requirement for blue line copies. We did in previous sections. And added the required signatures. So for summary review, there will be a signature block for the subdivision review officer, county full-time manager, and county treasurer. And we added passages to ensure adequate water supply to reflect changes to state statute as they were added in previous sections. And section 6.2.9 was deleted. It's a passage about variances for summary subdivisions. We added language to section 7.3, revise that section to refer to variances for all plat types. So this variance process described here for summary subdivision only variances would be deleted. And we did have a comment from Clayton Harrison concerning this section, 6.2.9, which reads, variance from design standards. Why is this section struck? Are variances still allowed? I see other verbiage on variances in the code, so I'm not sure why this is struck. And we also had a comment from Greg Harper. Clayton questioned why variances were stricken from paragraph 6, and will this affect summary review subdivisions only? Would the variance process be the exact same as it is now for all non-summary review subs? And I replied, hi Greg, I'll bring it up at the hearing, but section 6.2.9 was deleted because section 7.3 was revised to refer to variances for all plat types, summaries, preliminary plats, and exemptions. So I think that there was a reasoning behind that. Here in special procedures, under vacation, application and review for vacation. So we added language to this passage to clarify the review and approval process, required documentation, and to add an expiration. So this would read, any final plat filed in the office of the county clerk or portion thereof may be vacated upon application by the owners of the land proposed to be vacated, payment of the required administrative fee, and upon submission of the owners of the land proposed to be vacated of an acknowledged statement declaring the final plat or a portion of the final plat be vacated. And then we added copies of the vacation plat in number sufficient for review and supporting documentation shall be submitted to the subdivision review officer. Once the application is deemed complete, the subdivision review officer shall review the application documents within 14 days and advise the applicant of any necessary revisions. Supporting documents shall include, but are not limited to, documentation that any lien holder or title company in lieu of lien holder acknowledges plat. Supporting documents should also include letters of support for vacation from adjacent landowners and utility companies. If a revised vacation plat is not received within 12 months after receipt of the completed application, the application for exemption shall expire. An extension may be granted by the subdivision review officer. That should be changed to application for vacation.
Yeah,
Okay, so in the decision on vacation section, we added some language there to clarify the review and approval process. So now it reads, within 60 days after the date of receipt of the revised vacation plat accompanying the request for vacation, the Board of County Commissioners shall approve or deny the request. And moving on to variances. In the procedures section, we added language in this passage to include variances for plat types other than preliminary plats. Variances are most often seen with exemptions due to substandard lot size. So we added the language The section to read, each request shall be submitted in writing prior to or at the time of a request for preliminary plat approval, exemption plat map approval, or summary review subdivision approval on the prescribed form available from the subdivision review officer. And then the next section was revised to read, each request shall be considered at the same time as the application for preliminary plat approval, exemption plat map approval, or summary review subdivision approval. And then the next section, reading, if a variance is requested for a preliminary plat, each request shall be submitted along with the preliminary plat and supporting documentation to the review agencies. An opinion from each agency on the variance shall also be sought. Moving on to section 7.5, exemptions. We added this requirement for compliance plat approval because it is quite common for parcels to be non-compliant. As stated before, often these parcels were split by deed instead of split with county and or city approval. We also added other plat types that were not addressed previously. So this section titled Approval Required would read, it is unlawful for any person to divide a surface area of land, including land within a previously approved subdivision, into two or more parcels for the purpose of sale, lease, or other conveyance, or for building development, whether immediate or future, unless such person either obtains approval for a subdivision as provided in these regulations, or files and obtains approval for a claim of exemption as provided in this article. We added parcels of record conveyed after July 1st, 1997, without a county-approved plat must obtain county approval to be brought into compliance with these regulations. Plat types that shall follow this review and approval process include, but are not limited to, compliance plats and easement surveys, replats, and revised plats at the discretion of the subdivision review officer. So, under verification of exemption, we added a pre-application conference to be required for all plats, including exemptions. So it would read, a pre-application conference is required before application for exemption plat map review and approval. The pre-application process is described in Article 3 of these regulations. We revised the passage on application to clarify that a claim of exemption form is no longer accepted in lieu of an exemption plat map. We also added the requirement for the survey line work in digital format and clarified that the payment of the fee will be before review of the plat. So this section would read, any person claiming an exemption under the provisions of these regulations shall submit supporting documents and copies of an exemption plat map sufficient for review, prepared according to the map specifications set forth herein. The survey line work and lot numbers shall be submitted in electronic format acceptable to the subdivision review officer. Payment of the required administrative fee shall accompany each application for exemption. And under plat map specifications, we deleted if used, so this section would read the exemption plat map shall include the following information. Deleted the if used, since the map will be the only option. We added language to sync with the minimum standards for surveying in New Mexico. It would read identification numbers or letters for each lot on a plat with more than one lot. And then we added owner's certificate of intent to clarify the components of a plat. And in that example of owner's certificate of intent, we revised this to refer to the exemption definitions in the State Subdivision Act and or Article 2. So it would read, I certify that this transaction involves, here state the reasons for the claimed exemption, use language from NMSA 1978, section 47-6.2-M and or Article 2 of these regulations, instead of the claim of exemption form set forth in Appendix B. We deleted that part. And then we added language to clarify the required signatures of the county floodplain manager and county treasurer. There's the date there. And then we added the affidavit, so it would be a uniform requirement for all plats. So the affidavit section would read: the exemption survey shall be acknowledged by the owner and subdivider or their authorized agents in the manner required for the acknowledgement of deeds. The exemption survey shall be accompanied by an affidavit of the owner and subdivider or authorized agents stating whether or not the proposed exemption survey lies within the subdivision regulation jurisdiction of the county. And then we added a section for access and utility easement to prevent the division and sale of landlocked parcels where there is no clear easement to the property. There's a 20-foot minimum width in the fire code. So we added a section: access and utility easement. Access to each buildable parcel by access and utility easement must be provided. Access easements shall have a minimum width of 20 feet. Under the action section, we revise this passage to make it clear that the fee is required before review. Clarify the review process. Extend review to 14 days since floodplain and assessors reviews add time, and require mortgage holder acknowledgement. So it would read: on receipt of the fee, plat, and supporting documentation, subdivision review officer shall review the claim of exemption and supporting documents and shall mail written notice which states whether the exemption can be approved or is denied to the person claiming the exemption within 14 days after receipt of the completed claim of exemption, provided, however, that the 14-day period shall not begin to run until the person claiming the exemption has delivered a completed claim and all supporting documents to the subdivision review officer. Supporting documents shall include, but are not limited to, documentation that any lien holder or title company in lieu of lien holder acknowledges plat. Under the approval section, we revised this passage to clarify the review and approval process, extend review for reasons stated previously, and require that deeds or contracts be filed within 2 weeks of the plat filing to complete the changes shown on the plat. This is because it is common to see plats filed without deeds, causing confusion with chain of title. We want there to be a new deed that matches the legal description on the new plat. So this would read: approval. If the claim of exemption can be approved, or if the subdivision review officer fails to mail written notice to the claimant within 14 days after receipt of the completed claim of exemption and all supporting documents, the person claiming the exemption may divide the land in the manner proposed in the claim of exemption without complying with the provisions of these regulations. To finalize approval, the claimant must submit the revised exemption plat map for approval. Deeds or real estate contracts completing all changes shown on the plat must be recorded within 2 weeks of the plat recordation, unless reason for delay is submitted to the subdivision review officer. And we added an expiration passage, so there would be an expiration for exemption plats, reading: if the exemption plat map is not approved within 12 months after receipt of the completed claim of exemption, the application for exemption shall expire. An extension may be granted by the subdivision review officer. And then under section 7.5.3, roads and property dedicated to public use, we added a passage for clarity on road maintenance. So it reads: no streets or easements or public property of any kind shall be dedicated to the county on an exemption plat. No purported dedication of any such property shall be effective on an exemption plat, and the county shall not, by approving any exemption or exemption plat, accept such property. No maintenance will be done by the county unless accepted for maintenance by the Board of County Commissioners. Okay, so we moved this section. This is under section 8.5.2 C. We moved C to section 8.13.4.B.2, which is more appropriate. And we'll see that when we get there. Okay, so under 8.13, we've got that section we moved, and we put it under this section 2 for water. And we move this from section 8.5.2.c because it is more appropriate here. We also changed the wording to reference base flood elevation as per the floodplain manager. Now this section would read, specific comments and proposed actions shall be developed to deal with increased amounts of runoff resulting from development. All subdivisions shall be planned and located so that a building pad is available on each lot whose elevation is at least 1 foot above the base flood elevation, BFE, as previously defined. All roads shall be designed so that they are fully usable during a 25-year storm. And then under Article 9, administrative fees, we revised this article to clarify that fees are non-refundable and state that fees are set by resolution. So it would read, any person desiring to subdivide land in the county shall pay the non-refundable administrative fees set by resolution by the Board of County Commissioners. And we added this section of private remedies outlined in state statute that are available to purchasers of properties that are in violation. So we added 11.2.6 private remedies. I'm going to read all this, Doug, or this is
You're just
basically,
quoting state statute?
yeah, we're just quoting state statute here. Private remedies. And we added this section here, the language here to reference this current amendment. The third amendment of these regulations was adopted on blank 2020 and became effective blank 2020. And, If there are
Maybe page 89.
any changes here, index or anything yet. These appendix. Next change is going to be deleting this claim of exemption form. As previously described, we removed this form to eliminate the option of submitting the form in lieu of an exemption survey plat. This entire form was deleted. There's some more applications at the end. I believe one of these were altered. So
I think that was it.
I think that's it. Yep.
So for those who are participating either by WebEx or over the phone, if you have any final comments you'd like to make, now would be the time to make them.
When you say that, there's multiple places in here where it says acceptable to the subdivision review officer, is there going to be any place where those specific requirements per the subdivision review officer are listed? That way it's kind of in black and white at the time of any of these reviews or through any of these processes?
Mr. Lane, I think that's going to be dealt with administratively. More of just the procedure of, I'll accept, AutoCAD format for the line work or shapefile. But, as technologies change and we might need an additional format submitted, we don't want to go back and revise these regulations every time,
Okay. Yeah, and I understand that. I've had issues with some regulation agencies regarding survey plats where there has not been a defined set of requirements, and I've had run-ins where, it's like I'll hear one thing one day and I'll make those changes or make these or provide those types of things for a review, and then I'll get comments back that contradict what was previously stated. So I'm just curious as to how we're going to avoid that in the future.
Right, and whatever format's going to be acceptable to me on that type of submittal, I'll make it clear in my comments. If it's not clear already, before you submit that, I'll comment back that I want it in such and such format, or I'll need an additional document in PDF format or something like that. And we
Okay.
can
Okay.
deal with it that way. So.
Awesome. Okay. Thank you.
Anyone else? So before we adjourn, just so you know, we will prepare our report and submit this to the Board of County Commissioners for their consideration on December 15th. With any other comments we might get from reviewing agencies from the state. To date, we don't have any of those. We may not get any of those, but that's where we are. If nobody has anything further, we'll be adjourned. Okay, we're done. Thank you, Devin.